Welcome to our Informed Consent training series, our fall 2025 training series. This one is on building from basics. So it's about understanding the basic requirements of informed consent on your journey toward IRB approval. I'm Nicole Vouvalis. I'm the Director of Human Research Protections here at Utah State University, which means I work very closely with the IRB and coordinate most of its activities, but also oversee our Human Research Protection Program, which I'll introduce you to in a moment. But first, let's talk about the Institutional Review Board, the body most of you are familiar with, and probably how you received information about this training. The Institutional Review Board is an independent committee that is charged with the ethical review, revision, and approval of research involving human participants. Members of USU's Institutional Review Board further the university's research mission by prospectively reviewing proposed research involving human participants in order to ensure the protection of those research participants, that justice, beneficence, and respect for persons is present in all of USU's research involving human participants, in the creation of a culture of ethical concern and prioritization of research participant interests, and to ensure compliance with international, indigenous, sovereign, federal, state, local, and university requirements for conducting research with living people. So that's the board itself. The board itself is situated within Utah State University's broader Human Research Protection Program. So here's a visual of what our Human Research Protection Program looks like. It is split into three primary areas. The first is the USU offices and personnel who share in the goal of promoting infrastructures for research at USU that prioritize the protection of human research participants in all work. So there on the left, you can see the Human Research Protections Office. That's the office that I oversee. And so my colleagues and I do a number of things to support the human research enterprise here at USU. We do trainings like this one and host the city training, which allows you to train across institution and receive reusable content that helps you engage safely and ethically with human subjects in research. We coordinate with other offices who have an arm in ensuring that human subjects research is being carried out safely and in a compliant manner. So if, for example, you have a conflict of interest in a human subjects research project that you propose, we're not conflict of interest experts and we don't pretend to be. So we work very closely with the Research Integrity and Compliance Office to put a conflict of interest management plan for that project in place that allows you to carry your research forward. But we coordinate that process with you. And so in that way, our office, the Human Research Protections Office, gets to be the hub in the spoke of the wheel that is all of these important pieces of the university that are contributing toward an ethical and compliant infrastructure for research with human subjects. We also interface with participants. So if somebody has a concern or a complaint about their participation, we let them know that they can speak with us about that, and we try to work with you and them to get that resolved. The entity that you're most familiar with that I just explained is the IRB. The IRB is the entity that is in charge of actually reviewing and approving the research. So there's a lot of stuff that goes into preparing for approval. There's a lot of stuff that goes on after it is approved. And the IRB's role is to ensure compliance with all of the federal requirements and ethical infrastructures and codes that are in place for the work that is being proposed by USU researchers. And then finally, and I'd argue the most important piece is the researchers. You all are the ones conceiving of the ideas and implementing them, and the ones who are ultimately charged with implementing the protections in your work. So we can put together the most beautiful and respectful plan for the conduct of human subjects research, but unless the researchers carry that out with fidelity, it doesn't mean anything. And that's why I say I think it's the most important part of our Human Research Protection Program. All of that is overseen by the Vice President for Research, currently Dr. Lisa Barreau. And because a lot of those responsibilities are quite large, she doesn't engage in every single one of them, and that's where our office steps in to help. So that's just a little bit about our Human Research Protection Program. So let's move on to a little bit about how we do the work that we do. In order to accept any federal funding for any research involving human participants, Utah State University is required to establish standards for all of its human subjects research. Utah State University applies the Belmont Report principles to the entirety of its human subjects research portfolio. And in general, we are applying 45 CFR 46, mostly because we only have one system and we can't really apply different standards to differently sponsored research. So in practice, if you submit to the USU IRB, you are submitting to a structure that utilizes both the Belmont Report and 45 CFR 46, or the Common Rule, to its research. The Common Rule contains requirements for the composition of IRBs, minimum criteria for approval for human subjects research, standards for informed consent, and other important tenets of the IRB process and its requirements. The Common Rule also has a subpart for certain populations. And so we see a lot of work in subparts C and D. For example, subpart B is for pregnant persons, which is not really considered a vulnerable population any longer. So we work in those other subparts. But that's the entirety of the Common Rule and all of the standards that we must be responsive to in our review processes. So starting to focus that a little bit more on today's topic, which is the Belmont, or informed consent, we start with the Belmont Report. The Belmont Report is a foundational document for research involving human participants in the United States. The National Research Act of 1974 created a commission and charged it with identifying basic ethical principles that should underlie the conduct of both biomedical and behavioral research involving human participants. That commission, the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research, met at the Smithsonian Belmont Conference Center, and that's why it's called the Belmont Report. The Belmont Report was adopted by what is now Health and Human Services, and just as any other administrative law proceeding, published to the Federal Register for notice and comment, and after a period of time, formally adopted as policy by the federal government. And here we just have a few facts and a picture of the institution from whence the document came. So most importantly to today's topic, the Belmont Report articulates three main principles: respect for persons, justice, and beneficence. We're going to focus today on the principle of respect for persons. It is the primary driver behind informed consent requirements. We'll talk about how that became later codified into 45 CFR 46. But using these standards as a benchmark, people are taught respect for persons means giving appropriate weight to the person's opinion and choices. The Belmont Report itself specifies some information about respect for persons, but then has what's called applications. So it talks about each principle broadly, and then it applies those principles to common pieces of what the Belmont Report says should be present in all human subjects research. And so here on the right, we see two of those applications as outlined in the Belmont Report. So we demonstrate respect for persons by ensuring that people have the information that they need to make an informed decision. And we demonstrate respect for persons by providing extensive protection for certain populations. So where, for example, someone might not be capable of full self-determination. That's a summary of the Belmont Report's proceedings on informed consent and as it pertains to respect for persons. The Belmont Report is a part of all of our city trainings, and so if you did not read it carefully then, I would encourage you to go back and revisit it before you file a protocol. It's a very short document, and it contains some really useful insights. It's a little bit surprising how many of them, despite how long ago this was and how far the research enterprise has come, how many of them are still really relevant to the work that we see in our office today. So the federal policy for the protection of human subjects is how we actually put the Belmont Report into regulatory practice. So we call it the Common Rule. The Common Rule is so named because it was codified and adopted by 15 different federal departments and agencies at the time. Now that number is 19 federal agencies as signatories to the Common Rule. One of the big ones being missing is the FDA. They are, however, in the process of harmonizing their regulations to be in line with the common rule. But so that's why it's called the common rule. It's because it's common across several different agencies who deal with human subjects research at the federal level. And it is really just an application of the Belmont principles and the Belmont report to specific criteria that the federal government wanted to see in place before human subjects research could proceed. That criteria applies broadly. It applies to any institution conducting human subjects research. It applies in many cases to sponsors who are funding human subjects research. And it certainly applies to criteria for approval for human subjects research. So you'll hear it referred to as the common rule or 45 CFR 46 throughout this presentation. Both are correct. The common rule is codified at 45 Code of Federal Regulations, section 46. So you might hear me use both of those terms throughout. When we're talking about the common rule standards for informed consent, we're talking about two general important structures. We are talking about the informed consent process, and we are talking about the informed consent documentation. It represents an outsized proportion of the common rule. Informed consent does. So the common rule itself is just 11 pages of text, again, not terribly long or complex. 4 of those pages are dedicated entirely to informed consent processes and informed consent documentation requirements. So that tells you a little bit about how important that is, because the common rule spans a lot of things, as I just mentioned. It outlines responsibilities that institutions have. It outlines responsibilities that sponsors have. It outlines criteria that researchers must put in place before they can gain approval. It outlines really specific stuff the IRB has to do or consider. And then 4 pages just about informed consent. And I think that that's really representative too of the import IRBs and human research protection programs place on informed consent. Arguably, I think it is the most important part of what we do here at Utah State University within the IRB and regulatory compliance side of the work that we do. Our biggest concerns as a board center around participants being able to fully understand what is being asked of them and ensuring that the most important facets of that understanding are being communicated adequately. And I'll argue safely in terms of the process as well. So we'll dig into some of those pieces. But broadly, we can think about informed consent standards as being the Belmont principles, so respect for persons and the applications that are articulated there going along with it, plus the common rule requirements, so those 4 pages of requirements outlined in the Code of Federal Regulations, plus our accreditation requirements. We are an accredited human research protection program, which means that we assert to the scientific community and beyond that we are implementing our review standards at a high level, and we're engaging with best ethical practices in the field of human research protections. And we are also taking into account state, federal, sovereign, international, or other context-specific requirements. For example, if you are doing work in the European Union, your informed consent process is going to be how you comply with the GDPR. The GDPR has very specific requirements about what must be in place for people to collect information about people who reside in the European Union. And so those are some of the international and context-specific requirements that we would be taking a look at for your informed consent documentation and your informed consent process. There are some jurisdictions, for example, that don't allow you to collect informed consent like in a hospital or medical setting. And so that would be a context-specific expectation that we would need to ensure is in place in your research before it is approved. So we're going to look a little bit at I'm just going to mention some context-specific requirements. These are 2 very common regulatory ones that we see. HIPAA, or think of that as the law that protects your health and medical information on the whole, is a federal law that dictates how data can be shared, how it can even be accessed, like looked at in order to perform research. and how you approach people and what you must say to them. So it would be in addition to our informed consent process, but it is a part of the informed consent process because it impacts what you are telling people about how you're going to handle their data as you are collecting their informed consent. Same with FERPA. So FERPA protects educational records. So a student's educational records are protected and they're really sort of owned either by the student's parent when they're in a K-12 setting or by the student themselves when they enter a higher education setting. And so we are required to ensure that any research working with that kind of data is compliant with those requirements. And often, again, that means your informed consent process gets modified in order to accommodate these additional requirements. I mentioned the GDPR, the General Data Protection Regulation, and the EU, and the Personal Information Protection Law in China. Many international jurisdictions now have their own data protection law in place. And so when we are reviewing your protocol, one of the things that we're doing is my office is in charge of performing a technical and regulatory review. What that means, technical means like you have all the pieces there, everything is as it's supposed to be, and it all makes sense. There's nothing contradictory in your application, nothing contradictory in your uploads, pieces like that, but also the regulatory piece, right? So making sure that you're not proposing to collect data from residents of the European Union in a way that is not allowed by the GDPR. And then here in the United States, there are a number of additional requirements at the federal level. So we have the Protection of People Rights Amendments, which say that you cannot ask certain types of participants certain things in certain settings, absent affirmative parental consent. So a lot of people think about opt-out consents in an education setting, but depending on what you're asking, you could not do an opt-out, even if the data you're collecting are anonymous. And then these last two talk about how we can collect documentation of informed consent. And so there are requirements for ensuring, for example, under the High Tech Act, that last one there, if you are collecting an electronic signature for a FERPA protected process, there are certain stringent requirements that must be in place before you can collect that signature. So you can't just have like a Qualtrics survey out to whoever might sign it. Under HIPAA and the High Tech Act, you actually are required to verify that person's identity somehow. And so these are all pieces of what we are looking at when we're seeing your protocol submission that touch on what should be reflected in your informed consent process and your informed consent document. And then we also have just something to think about, the Utah Minor Protection and Social Media Act. Right now it is stayed by the courts in terms of the documentation piece that would be relevant to research. So lots of things going on that our office is checking for in making sure that your informed consent process is both ethical and compliant. So when we're talking about informed consent, we are talking about the communication process during which an individual is given important information about a procedure or treatment, and that interaction results in agreement or disagreement by that individual to undergo the procedure or treatment based on their knowledge of those facts. And in most cases, in order for informed consent to be legally effective, it must also be documented. So as I mentioned a few slides ago, we're talking both about process as well as documentation, or the paper or the electronic form that you are giving to people to help them understand something about your study. This is the baseline process under the common rule. So the common rule assumes this is what researchers are going to do. That a researcher is going to give to someone who's considering research participation complete and relevant information about the study, that the prospective participant then is able to make a decision about whether to enroll after having had an opportunity to consult with others. That could mean members of the research team who might be able to answer their questions. That could be members of their family who might have to drive them to study appointments. That could mean talking to us about their rights as a research participant. So any of those folks that might have an impact on their decision-making process, a prospective participant needs time to be able to engage with those parties before they make a decision. And then finally, that prospective participant becomes a participant by signing and printing their name as well as the date of their agreement on a document, and an executed copy is returned to them for their own records. That is the baseline process that the common rule assumes will take place in all human subjects research. This is what we refer to as an unaltered process. We will have an entire training on waivers and alterations next month. And so if you are interested in a consent process that varies from this consent process, I would highly encourage you to attend that training, because we're going to get into the nitty-gritty of all of those criteria and the assessments that we need to make and situations in which they are or are not appropriate. But again, so this is our unaltered or our baseline informed consent process. There are some things you cannot do in that process. And mostly what we're looking at there is the avoidance of undue influence or coercion. Um, while those terms are often used interchangeably, it's really important to know that they are distinct. Coercion is the practice of persuading someone to do something by the use of force or threats. Not very common in our research settings, but a lot of people say coercion. What they mean is actually undue influence, which is the influence by which a person is induced to act other than by their own free will without adequate attention to the consequences. So undue influence is mostly the thing we're trying to avoid in our informed consent processes. Of course, we're also trying to avoid coercion. That should go without saying. Threatening someone or using force to get them to do a thing is wildly inconsistent with the principle of respect for persons, and all of the requirements outlined in the common rule. But it's also not really a situation we're commonly faced with. So when we're looking at these assessments, we're really looking to avoid undue influence. What might that look like? So compensation that is so great relative to the study procedures that research participants aren't really considering the procedures, right? It's that compensation is an influence by which a person is induced to act. Like, $500. What do you want from me? Yeah, fine. That would be an example of undue influence at work via the compensation process you've outlined. Someone in a position of power asking a prospective research participant to agree to the research. For example, an instructor asking their own students might not be cognizant of that power dynamic, but it exists. That instructor is able to assign a grade to their student at the end of the semester, and students have to wonder, will my grade or how I'm viewed in this class or my ability to get a letter of recommendation from this person be impacted if I decide I really don't want to do this research? Like, I don't want to read anything extra, but I don't want to make my professor mad either. Those are things that people should not have to contend with when they are engaging in a decision about whether to participate in research. Like, the very prospect of them having to do that should be removed from any informed consent process that is designed. So how do people do research with their own students? Great question. We have an entire training dedicated to that, recorded with slides on our website, but briefly, the answer to that is bringing in someone who has no relationship to the students, who's going to conduct that informed consent process, and who will not tell the faculty member who chose to participate or not until the semester has ended. There are other options, but that's one example of the way we navigate those situations. Finally, another example, informing a participant that they cannot access needed medical care unless they participate in research. Or not even informing, but implying. I think the implication is actually in some ways more nefarious than an actual information point. So what might that look like? Including an informed consent document in intake paperwork for a place that does crisis type work. So for example, if someone were presenting to a domestic violence or abuse shelter in a moment of intense need, and an informed consent document is just in the paperwork with all the other stuff you have to complete in order to receive services from that space. It's somewhat implied by virtue of that being included in the intake paperwork that like this is a thing this place needs from you in order for you to move to the next step. And so we would ask that that be separated out from that process, that once participants are safe and calm and in a space where they can engage in some reflection, that they be asked to participate in research at that time rather than during what is probably a pretty hectic and chaotic intake process. So those are the sorts of things that we're really looking very closely at an informed consent process to make sure are not present. We're looking at power dynamics. We're looking at the urgency of the situation. We're looking at the extent to which a reasonable person might infer that this actually isn't really an option for them or that there's going to be a negative consequence if they say no. All research participants should be free to say no to research at any time. That includes once they've started and certainly applies to before they've engaged. We're not going to go through all of these in detail, but I mentioned that 45 CFR 46 has 4 pages of requirements. This is one of those pages. So this is 45 CFR 46, section 116, titled General Requirements for Informed Consent. The first half of that section deals with the process for obtaining informed consent, and the second half is dedicated to the required and additional elements of consent. Required means that these elements are required in all cases, absent a waiver or alteration. Additional means that they apply when the study they apply to the study under review. So absent an indication that it will inhibit someone's ability to render meaningful informed consent, those additional elements should be included if they can be applied to the research project. All of this is also on our website, and importantly, you don't have to remember all of this because we provide templates that make sure that all of this information is something you can decide how to communicate to participants, but we nudge you to think about each of these elements, or in some cases, just provide template language. For example, a statement that participation is voluntary. We have such a statement in our templates, a statement that what they are doing is research. We have a statement suggested in our templates. So you do not have to reference 45 CFR 46, section 116. Here are the additional elements of informed consent. So these are the ones that if they apply, unless it would not be helpful, like it would actually hinder a research participant's ability to think carefully about the project, they should be included. And so, for example, the approximate number of participants that you expect to enroll in the study, that can have an impact in several directions. Some people just want to know, like, how many other people are going to do this thing? Or some people might want to know, oh, well, there are 8 $20 gift cards available to participants in this study. Yeah, I might be willing to do that for that amount. So, but how many participants are there? Like, are there going to be 8 gift cards for 40 people, or are there going to be 8 gift cards for 400 people? Because that does impact someone's expected value of participation. Again, compensation should not be the basis on which someone makes a decision, but it might be a basis on which someone chooses not to participate if they feel like their time is not being sufficiently valued. And then beyond those required and additional elements, we have further additional requirements. So the common rule says that an IRB shall require that information given to subjects, that we add anything that, in addition to those specifically mentioned in section 116, would meaningfully add to the protection of rights and welfare of the subject. And one of the rights of a subject is to fully understand the study. And so we do have several things that, while not specifically listed in section 116, are things that we add. Most of these are a product of our accreditation. So our accreditors have looked across the country and looked very carefully at what it is participants feel they need in order to know what they need to know before engaging in a study. And so some of those things are confidentiality disclosures. 45 CFR 46 does require that we share the extent to which information will be kept confidential, but it doesn't say, for example, it doesn't have any standards for like security of the data. And so we require disclosures about how that data will be secured. Payment or compensation information is not something that 45 CFR 46 requires, but it is something that most IRBs have found does matter to a participant's decision whether to participate in research. So we require it be included. Um, Use of information protected by other legal structures. So if you're going to use protected health information under HIPAA, it's really important that participants know whether that information remains subject to HIPAA after you use it, or whether you're going to do something to it that take those protections off for that information. Because that's sensitive stuff and people might not want it to be shared outside of the research context. But in certain cases, you could do that. So disclosing that to participants becomes important. If there's a conflict of interest in research, we often require that that be disclosed to research participants so that they know not just what the conflict is, but also in most cases, up to you, I suppose, how you're going to mitigate that conflict, which is something I think most research participants would want to know. Um, and then we may also require formatting changes or the use of images for enhanced comprehension. For example, if you're working with an elderly population, don't submit a informed consent document to us in 10-point font. That's going to be very difficult for your targeted population to read. And so while we're speaking to the common rule there a little bit in saying like it's our job to make sure that it is easily understandable to the population you're targeting, that's a space where we, might also say, hey, you're impacting your participants' ability to meaningfully engage in this process if you're making it difficult for them to read. Similarly, say you're working with children or an obscure piece of equipment that most people don't know how it works. We might want you to add images or pictures so that folks can better understand what they're signing up for. So all of those things that we just talked about on the last 6 slides, I think can be summarized in sort of splitting them into a few important and salient concepts. So complete disclosure. When we think about complete disclosure, we can think about the required elements of informed consent as set forth in 45 CFR 46, right? It means providing accurate and sufficient information about the study's purpose, the procedures, the known risks and benefits, any available alternatives. But critically, it also means not withholding information that you do know about. For example, if you think that 5 risks are possible, but you only list 4 because, ooh, that 5th sounds really bad, and I think it's really not going to happen. It could happen, but I doubt that it will. So if I say it, it's going to scare people off. You cannot do that. You must still disclose that 5th risk. But you can also use your informed consent document to outline how probable something is. For example, if you're exposing a participant to radiation, it simply is true that you are increasing the risk of cancer. But in most cases, it is true negligibly so. So you can say, this 10-minute procedure provides the same amount of radiation as existing on the planet for 2 years. Okay, well, I know what it's like to exist on this planet for 2 years, and I know that I haven't had any radiation-related problems so far in my life that can be tied to that. So maybe I don't really need to be concerned about this, short procedure exposing me to the same amount of radiation as 2 years worth of existence on this planet. Like, that's not a big deal. Doesn't mean you don't have to disclose it, but it means I get to say how much it matters to me, and I get to have that be informed by your accurate description of how probable that risk is or how really in context I should be thinking about it. Comprehensibility. The information has to be communicated in a way that allows your participants to accurately understand what participation in the study does or involves. If you're speaking to children about learning interventions, for example, it does not make sense to say, these structured learning activities can scaffold the development of executive functioning skills such as working memory, cognitive flexibility, and inhibitory control. That doesn't mean anything to an 8-year-old. Instead, you want to say, the learning games we're trying out here might help us learn how people in your grade, like you, use your brains to play, to stay focused, and to try new ways to solve problems. We're looking at that language level or how complex and how you're communicating that information to your research participants. You're writing your proposal for an academic audience. You're writing your protocol for people who have high levels of education, but also are kind of a lay audience. And you're writing your informed consent document, not just for any lay audience, but your lay audience. It needs to be tailored to the people you're talking to. Voluntariness is critical. We talked about it some in the context of your process, but your document needs to have the same consideration in mind. All research participation must be voluntary. It cannot come at the cost of oversized inducements, as we talked about, or based on an unwillingness to disrupt a power structure, and certainly not at the threat of coercion. It must simply make good sense for that participant at that time to engage in your study. So you're wanting to make sure that both your process and the information that's being communicated in your document support voluntariness. I will say nothing raises a red flag for my board members and me, like hearing, if we ask for informed consent, we're afraid no one will participate. That tells you something about your study design, not about the need for a weakened informed consent process. In most cases, our next training on alterations and waivers is going to talk in depth about some situations where that's not the case. But in general, where informed consent is possible, then you should really be thinking about how to enshrine voluntariness in both your process and your document. Appropriate audience. And here I do not mean equitable selection of subjects. Equitable selection of subjects, the topic of a whole other training, stands for the proposition that you haven't selected your participants merely because they're easy for you to access or something like that. That's a whole separate subject. When I say appropriate audience here, I mean that you're asking the right people at the right time in the right manner. If you're working with children, you're going to have an informed consent process that takes both parents or guardians and children into account. It means considering a process for involving a guardian or a legally authorized representative, next of kin, supported decision maker, whatever is appropriate, when you're working with adults who might be managing cognitive impairments or fluctuating cognitive capacity. It means knowing how you can stay in touch with your participants if you might gain meaningful information along the study's timeline that a participant would want to or should know that could impact their decision of whether to continue participating. So by appropriate audience, I mean that relevant information about your study is getting to the right people at the right time to make strong supported decisions. Finally, documentation. In the world of human research protections, if it isn't documented, it didn't happen. And if you are not going to get documentation of your informed consent process, that needs its own documentation from the IRB. So it's documentation all the way down, friends. Our next training on November 19th is going to go over what it would look like to waive documentation in your study, what that process is for you, what that process is for the IRB, what we must document and find before we can allow that to move forward, things like that. So please join us next month. The last slide has the date and time. But if you cannot, we record each of these trainings and we post them to the website along with the slides. So you will have access to it at a later time. I want to touch just one more second on appropriate audience because there are two populations commonly utilized in USU research who do require special attention to who's being asked for informed consent. First is children. Children are any persons who have not reached the age of majority as defined by the jurisdiction in which they are located. Most people think 18 and older. That is a vast oversimplification. And while it's true for most of the work that we do and many of the settings that we're doing it in, that misunderstanding can be detrimental to participants and to the research you conduct. So it's really important that you understand this in your own research setting. For example, in the United States, while all persons can vote at age 18, in Nebraska and Alabama, a person cannot consent to research procedures until they are 19. And so if you're releasing a national survey and you're just saying 18 and up, you are probably capturing children in those two states without an appropriate consent process for children. In some countries, children reach the age of majority anywhere from age 14 to 22, older in some cases. That's a more common band. In a plurality of states in the United States, there are ways a 16-year-old can become their own legal adult. For example, marriage is a common way that teenagers before age 18 become adults. In Utah, for example, and 19 other states, 16-year-olds can marry. If they are married, they are adults. So it's really important to think carefully about who a child is within the structure of your research. When you are working with children, informed consent encompasses three things. It encompasses the child's assent in most cases. It encompasses parental permission. Both of those things are required for informed consent. And then, of course, as we've talked about, it requires the documentation of those things, absent a waiver. So you're looking at what your child assent process looks like and what your parental permission process looks like. Assent, parental permission, that's what you need for informed consent when you're working with children. Absent, again, a waiver. The other population that we see a lot of work with that requires some thinking about who is being asked for informed consent at the appropriate time and in the appropriate way are adults with cognitive impairments. Um, This can be really tricky because so many states have different approaches to how this gets handled, and it's a rapidly moving field. So as we as a society learn more about, I'll say especially Alzheimer's and other related dementias, I think our process of thinking about what a good informed consent process looks like is also rapidly changing. So it's really important for you to think about this tiered process again in the specific context in which you're doing your work, if this is a population you want to work with. An adult with full cognitive function, in the moment you're speaking with them, may have already turned their legal decision-making over to another person because they're experiencing fluctuations in that capacity. If they've done so, even though they have full capacity in the time that they're interacting with you, they can't legally sign that document for themselves. You have to involve their legally authorized representative. Um, and so even though they pass a cognitive screener, they might not be the person who can say, yes, I want to participate in that study. And then who a legally authorized representative is can be tricky. So for some folks, there are agreements in place and a process for managing the decision-making process. Like some people have taken care of that already for themselves. And for others, there's no such thing. They haven't contemplated this ahead of time. Now we're at the point where we need it and we don't know what to do. And states, again, are approaching this all in very different ways. And it's even context specific. So where, my sister might be my legally authorized representative in some cases. My partner is probably my legally authorized representative in others. It depends on where I'm being asked to do something. How I make decisions about my health care are different than how my banking gets managed and my bills get paid. So it's really important too to understand the context in which you are working and who the appropriate person is to give informed, or I should say, legally authorized representative permission. And then, if possible, paired again with the impaired adult's assent. So if the person has the ability to understand what's going on, but just doesn't have the legal capacity to consent, it's still really important that you have a plan for having that talk with them and documenting, as always, the process that you've worked through. The complications of navigating these two processes does not negate the need for a strongly designed informed consent document and process. In fact, if anything, it enhances the need to think about this very carefully and ensure a responsive procedure for seeking and obtaining informed consent. We have training on both of these topics, working with children and working with adults with cognitive impairments on our website. So really recommend that if you're doing work with those populations, you check those trainings out. I'm going to end with just a couple of resources. These slides will be PDFed and added to the website. Honestly, that process is pretty fast, usually tomorrow. So a link to the Belmont Report, a video about the Belmont Report, which I found really helpful in terms of how folks were thinking about these requirements as they were thinking about documenting them and putting them into place. We also have informed consent templates. And I will say, we just yesterday finished up a workshop of really trying to even further simplify our informed consent templates. So we're going to workshop those to our board members as a whole before we release them. But in the next month or two, you can look for even further simplified informed consent templates and ones that are even more specific. For example, we have one assent template right now for children, and we're about to split that into three, one for different populations of age range. So really look forward to having those simplified and streamlined templates available for you folks. The Office for Human Research Protections has a participant-centered informed consent training on their website. Last I checked, it was still working despite the shutdown. So That's a great training that is like entirely dedicated to informed consent. So if you are a researcher and you're looking to have folks help out with your study and their only role would be informed consent, that might be a good training for you to suggest to them. And then these last two are ones I just include on every slide. Our website has a form to request a consultation. And we hurry up and get you scheduled, usually within just a couple of hours of you submitting that form, with, importantly, the person who's going to handle your protocol or review your issue. So that's why we use that form, is so that we can pair you up appropriately. And then we have a Slack instance that is asktheirb.us or .slack.com. And so we'll have an invite link, but that's also on every page of our website. So if you're at irb.usu.edu, scroll down, bottom left side of the screen are our socials, and our Slack invitation link is on there as well. So I want to take the next 10 minutes to answer any questions folks might have. I've been looking at the Q&A and I didn't see any come in, but now's your time. I'll move on to the next slide, but if a question comes in, I will happily come back to it. So again, here's that QR code as promised for requesting a training topic for the spring 2026 semester. And our next upcoming training is on informed consent alterations and waivers. Shortly after this training, we'll update the homepage of our website with a registration link for that training. So just irb.usu.edu, you'll be able to find it. And so if you're interested in what alterations of your documentation process, or even the informed consent process altogether, or the use of deception or misinformation in research, if any of those topics interest you, I hope to see you on November 19th. Still no questions, so I guess we will just go ahead and wrap up and return a few minutes to you in your day. Thanks so much for spending the time with us, and hope you have a great rest of your week.